Good morning, friends. I am recording this extempore speech on the topic of frauds. As all you may be aware, Section 447 of the Companies Act 2013 defines frauds in a way which is different from what we have been understanding for all these years. Fraud, as an essential ingredient, will contain any manipulation of facts or concealment of facts or omission to furnish relevant facts. The purpose is to deceive. So what the Section 447 definition says is, if a person indulges in fraud with an intention to deceive or to gain undue advantage or to injure the interests of the companies, its shareholders, creditors, or any other stakeholders or any other person. Or if the person in the company is an officer, let us say, or a manager who is abusing the position and his powers and commits a fraud, whether or not a wrongful gain or wrongful loss is made, it is a fraud. The fraud is punishable in a very peculiar way. The Act puts the frauds into three buckets. The first bucket is something where the amount involved in the fraud is rupees 10 lakhs or 1% of the turnover, whichever is lower. And in that case, the punishment provided is the person who is guilty of such a fraud is punishable with imprisonment up to a period of 5 years. It means it can be 1 day, it can be 5 years. Or with a fine of rupees 50 lakhs or with both. The other bucket is again a fraud where the amount involved is more than 10 lakhs or 1% of the turnover, whichever is lower. And in such a case, the fraud is punishable with imprisonment for a period not less than 6 months, but which may extend up to 10 years. So therefore, fraud in the second bucket is again in terms of value of fraud above 10 lakhs or 1% of the turnover, whichever is lower. And in that case, the punishment is minimum of 6 months, maximum of 10 years. The fine, it is also punishable with fine in addition to imprisonment, together with imprisonment. The fine is the amount involved in the fraud, or it can extend up to twice the amount of the fraud. Now you can see the second bucket, and the third bucket is very peculiar, where the amount is more than 10 lakhs and it involves public interest. In such a case, Section 447 says the imprisonment shall not be less than 3 years. So therefore, three buckets are there. One is a bucket where the amount involved is 10 lakhs or 1% lower than, less than 10 lakhs or 1% of the turnover, whichever is lower. And it doesn't involve public interest. The second bucket is the amount involved is more than 10 lakhs or 1% of the turnover, whichever is lower, and it involves public interest. The third is amount involved is more than 10 lakhs or 1% of the turnover and there is no public interest component. These are all the three buckets. So we must remember 447 is a very dangerous provision which can be invoked due to various ways, due to various methods in which officers of the companies have indulged in frauds. Let us look at what is the impact of an offence involving 447. From 447, you should travel to 212 of the Companies Act. Section 212 of the Companies Act says the offence punishable as fraud under Section 447 is a cognizable offence and the bail is not granted. The conditions for grant of bail is stipulated under 212 subsection 6, which is like an offence under the Prevention of Money Laundering Act and several severe offences such as money laundering. So therefore, normally, if an offence of fraud is committed and if a person is accused of such an offence, he is found to be guilty of an offence, the arrest of that person is very, very tricky because it is a non-cognizable and it is a cognizable offence and the bail is not granted so easily. Bail conditions are very difficult unless you comply with subsection 6 conditions. So 212 is directly connected with 447. In my opinion, this 212 subsection 6 should have been part of 447 itself instead of going about saying about 3 buckets of frauds. 3 buckets of categories we can say, for the purpose of varied degrees of punishments. Apart from this 212, we have a host of other sections which also refer to 447. For instance, you can take section 7, where a person furnishes false information, incorrect information with an intent to defraud at the time of incorporation of the company, punishable under 447 as fraud. For example, section 8, companies with not-for-profit companies. If the company is found to be carrying on business with an intention to defraud, punishable under 447. 34. For example, if a person furnishes false and incorrect particulars with an intention to defraud in a prospectus, offer document, etc., punishable as fraud under 447. Section 38, where a person is making applications in fictitious names, impersonation, 447 comes into play. For example, 46, where a person is issuing duplicate certificates with an intention to defraud, it is punishable as an offence under 447. You must understand this is the same as section 84 of the 1956 Act. Then you have 56, where a person, a depository or a depository participant transfers shares with an intention to defraud. Straight away you can move the snake and ladder and go to 447 from 56. Similarly, 66, in the case of reduction of capital, if a person furnishes, for example, he doesn't furnish the name of a creditor who is entitled to object, or he furnishes wrong figures like what is the amount debt or claim owed. Under section 66, he gets the reduction of capital through by furnishing false information or suppressing material information. Straight away from 66 to 447, you can go. 76, that is again a peculiar section with respect to deposits. 76 is coming into play, 75, not 76. 75 comes into play in the case of an offence relating to 74, which is deposits accepted prior to the commencement of the Companies Act 2013, that is 1st April 2013. And if it is found that the deposits were accepted by the company with an intention to defraud the depositors, straight away the offence is punishable under fraud category under section 447. 76A is where like 75 relating to 74. 76A relates to 73 and 76. You must be aware 75 is confined to offences relating to deposits prior to the coming into force of the Companies Act 2013, whereas 76A is about 73 and 76, acceptance of deposits from public or eligible companies, etc., etc. These are all coming into play after the commencement of the Companies Act 2013. 76A is one provision which again links the matter to 447. Then 86. The provisions of 86 are related to filing of particulars of charges. When a person files false particulars, omits to file particulars with an intention to defraud, for the charges particulars are required to be registered under 77, modification of charges, etc., etc. And if it doesn't do that, and he had it under 447. Section 90, you must be aware the latest provision relating to significant beneficial owners. Again, if there is a false particular, incorrect particulars, 447, it invites section 90 also. Then you may have read about 140, where the auditor is playing fraud. Auditor acts in collusion with the management of the company, furnishes false particulars, fails to, with an intention to defraud, fails to furnish information which is proper, fails to furnish correct information, fails to furnish proper status of the company's financial affairs, the auditor is liable to be punished for fraud under 447. This comes under 140. Then you have provisions like 206, where inquiry or inspection takes place, company furnishes information which is fraudulent in nature, furnishes or fails to furnish, suppresses, furnishes in false particulars, incorrect particulars. 206, go to 447. 212, I have already described. There is nothing like fraud punishment for an offence by way of fraud under 212. 212 is only intended for saying it is a cognizable offence and bail conditions are difficult. Take 213, like 206 comes from inspection or inquiry by ROC officers of the Ministry of like inspectors. 213 is an application to make an application before the NCLT for ordering an investigation to the affairs of the company. In the course of investigation, if it is found that the company is carrying on business which is fraudulent, 447 is attracted under this thing. 229, during the course of investigation, again, if it is found the company has been carrying on its business for fraudulent purpose, 447. 251, if a person for fraudulent purpose applies for removal of name, again go to 447. Then go to 339 of the Companies Act, where in the course of winding up rules are already announced. It is coming from 1st April 2020. Of course, we will have the lockdown and all, but provisions are going to be enabled and application under 271, 272 can be filed for winding up of a company. Other than cases coming under the IBC and under sections 59 of the Insolvency Bankruptcy Code for voluntary liquidation, there can be other reasons like ROC finding MCA of finding some company to be wound up because it is against the national integrity and security, or the company is carrying on for fraudulent purpose. So these are all the matters which are coming under 271, 272. A company liquidator will be appointed, and if the company liquidator finds that during the course of winding up, 339 comes into play. It says if a company is found to have been carrying on its business for a winding up, during the course of winding up for a fraudulent purpose, 339 also takes you to 447. So therefore, friends, you have several provisions which are referable to 447, and all these provisions today we have discussed from section 7 to 339. All these provisions are prior to 447. Now you have one more section left, that is next to 447, which is 448, where a person in any statement, return, certificate, this is what we always do every day in compliance in CS. So many certificates are given. I remember a recent case where in the annual return somebody's name is not recorded. The ROC has slapped a notice on the practicing company secretary inviting reference to 447 in a show cause notice issued under 448. So therefore, friends, let us be aware the ways of doing the business, the ways in which business is carried on, the ways in which auditors are certifying professionals like us do the job at the time of incorporation to until the winding up. We have to be careful. Otherwise, we may be falling under one of the buckets, the three buckets I have told you under 447. Let us be very careful in these 21 days of COVID-19 lockdown. Let us understand what we have not done or what we should not have done, what should not be practiced. All these things can be thought about keeping 447 in mind. Thank you.